been working in this environment with startups since the last over the past, let's say, three years. And I am a Portuguese legal counsel. I have been working with startups in the UK, and that cross over 26 at least jurisdictions from Asia to the United States. I am also a certified chair of advisory boards, a data protection officer, and I think at least today I can give you an idea of what you need to incorporate your startup. Okay, so the title of this webinar is from the idea to incorporation, legal essentials that every startup must get right. But before we start, I would like to have some idea where are you based, so that can you post it in the chat so that I can see where are you based? Okay, can see already some answers here. Some Netherlands, India. Okay, fine. Please continue. That this will be interesting. Um, so if we start by the 2 million or 10 million question, uh, what do 9 of out Europeans what do 9 out of 10 Europeans failed startups having in common? Do you have any idea? Do you want to post on the chat if you have any idea? Don't be shy. I want you to engage with me in this presentation. Okay, so I start to see. Okay, they don't raise money. It's the concept. It's the startup the way they start up. It's the product concept as well. Not covering what they need. This might be one of the answers, but what we can do here is today's reality check, right? So 90% of the startups fail across Europe, and only 18%, sorry, not 19, of the first-time founders are succeeded. And the failures aren't only because of what you are saying here in the chat and about what we think that is poor products, but poor products concept, money, they don't raise enough money. Yes, but they also don't raise enough money because they don't build trust from founders as well. These are different topics here that we can address. But I can say that most of them are for poor legal foundations. So today, what I can say is that we are trying to give you some tools how to address these challenges, and some ideas how to structure a company and be successful. Okay, so regarding our agenda today, first we are gonna address the company structure, choose the right foundation, for example, in EU markets, founders agreements. So we are gonna try to prevent, because litigation is always something that can happen. Prevent partnership disasters, vesting schedules, protect everyone's interest. This is important because, of course, startups are to make money, but also to protect the company. Option pools, How do we attract and retain European talent? Action plan. I promise that in the end, I will give you an action plan for 90 days with a legal checklist. And we will give you some time for specific questions. Okay? So let's start with the company structure foundation. Before this, I want to make here a disclaimer. None of these cases have real locations or real names here. So for confidentiality purpose, I changed a lot of ideas on this in terms of locations, and even the business, it's a different business, okay? So we can identify what are the startups that we are talking about. Okay, so imagine this. Most of the times what happens is we have 3 brilliant co-founders, 2 brilliant co-founders, whatever number of co-founders that we have. In this case, we had 3 brilliant co-founders that built a fintech startup in Berlin for 2 years. No proper incorporation. And when they had someone interested in acquiring their startup, they discovered that they couldn't complete the transaction because legally the company structure was a nightmare. And what happened? The deal collapsed. So what does this show to us is that not only to be a successful startup and to scale up and to be a 1 billion company, it's important to have the right structure, but also it is important to have the right structure for founders and to have the right structure to be acquired. Sometimes founders come to me and they say, oh, we don't need the right structure. When someone comes to invest on us, we just sell and that's it. And this is not correct, because sometimes even if you have this idea, the deal can collapse, as we can see in this case. So this is a totally fatal mistake. Starting without proper legal structure, what happens also is that you are personally liable. Each of the founders is personally liable for everything. Your house, your savings, your future income, all at risk, at least under European law. So one of the important things that we can discuss also here is choosing your European jurisdiction, right? So for example, if you decide to choose UK, you will have advantage: English common law, strong IP protection, global recognition, best for B2B SaaS, fintech, and international expansion. Brexit considerations. Of course, we need to think that at the moment UK is also outside of European Union, so we might need a EU subsidiary for some business. It depends, or even for granting. We will discuss this later, because to be eligible for some grants, you will need to have a UK subsidiary, European subsidiary. For example, if you try to see the Dutch market, so you have advantage: EU access. The tax treaties are good, and you have a flexible structure, best for tech startups and the European headquarters of the company. So it's popular with Uber, Booking, Spotify. You know this for other companies. So, and then if we think also Germany has a strong legal framework, credibility, EU market access. What are the issues here? So the minimum capital that you need is 25k, different from other jurisdictions. It has a complex administration. It's good for deep tech, manufacturing, enterprise software. Then you have the Estonian, for example, digital first. They also have a residency program, deferred stocks on reinvested profits, best for digital nomads, early stage startups, crypto, blockchain. Note it is getting more popular, but we need to consider all the requirements that we have for these startups, for this incorporation. If you think for international expansion, the holding structure, many successful startups use the parent in Netherlands or in the UK. Then it depends. The subsidiaries, they have local entities where in their key markets. For example, we have Adyen, Revolut, and 26. So it's very important that you define your strategy when you are incorporating and creating your legal strategy as well. So if you think that legal is something that can come after, you are totally wrong. And the first thing that you should start thinking is about your legal strategy. So incorporate before you start writing code. Not exactly like this, but incorporate when you have your idea and you have defined your business strategy. Sign contracts before you sign any contracts with customers or suppliers. Hire anyone, including co-founders. I know that this is difficult, but since you have 2 or 3 people thinking about one idea, just sit and think about your business strategy. Where do you want to incorporate? Apply, and this connects to what I said before you apply to grants or government funding, because if you think about grants and government funding, you will potentially need to be located in the place in that country or European country, or it depends on the grant. So decide what grants you are trying to apply. What is your scope in terms of grants? And very important, before you create any intellectual property, because after creating intellectual property, you will have to assign all of this. And I know situations where people are creating the intellectual property in the beginning, and then the founder, or without being formally a founder, just runs with the IP because they applied for the patent and they are waiting for this, or they created all the idea and someone just goes because we don't have NDAs or anything created before before the creation of the IP. We don't have the the, the founders agreement signed or anything. Then, very important. Why is this all important? Because then we have all the compliance related to this. GDPR, AI Act, tax complications, and employment law issues that can cost you millions later. So we need to think about this before starting. Brexit and the EU considerations. This is important for people that are thinking more in an international way to scale up, and they decide to go to the London market to be more international. So UK companies may need EU presence for certain activities, as I said before. We need to consider dual structure, UK and EU entity, and also important data transfers. That is very important. People usually forget this, because being with the EU and UK, you have data transfers. So I give you one action. If you have not properly incorporated yet, do it as soon as possible. Consider your target markets and choose accordingly. Any questions? No? Okay, I think.
All well.
Okay, I think I can proceed. So now let's go to your insurance policy, as I like to call it, because founders agreements, okay, are very important. And let's address the elephant in the room, because when we start, we are all friends. So as I say, we met at the university, we trust each other completely, we don't need formal paperwork. This is a common conversation that I have with founders. But the reality is that European courts are full of former friends fighting, and some of them over startup equity, in discussions that are difficult sometimes to solve. So another case study, and as I said, I have changed all the names and locations, okay? So we have a successful Dutch AI startup founded by 3 university friends, no founder agreement. The equity was split equally between all of them verbally, okay? One founder wanted to relocate to Silicon Valley, and what happened was that we had 2 years of litigation because we were lucky, and we ended up in an agreement with 500 in legal fees. The company nearly got bankrupt from the legal costs because it was in the beginning, and the company couldn't recover from this. Okay, so what is the result? Something that could be a successful startup, because the basics and the pillars weren't set up, never got to the market because they spent all the funding in legal costs. So European legal considerations. Why founders agreements are critical? As I said, they are critical for everyone, but in Europe we must consider critical because we have diverse legal systems. So for example, one thing that is very, very complicated is that we have civil law and common law, and we also have European law, so above it. So European, civil law, common law. Continental countries, most of them have civil law. UK, common law, totally different. The pillars are totally different. Contractual schemes are also totally different. So you need to have this in consideration when you start. Again, employment law protection in Europe, in continental Europe, is very strong. The protection of employees is a very strong stance, and the termination rights, even for founders, because they are considered employees, even if we don't think about it when we are starting, makes the termination complex. Okay, For example, if one founder decides to leave because he's not agreeing with what is being done in the company, for example, in our European AI, as I mentioned before, some I would say almost all the European countries have difficulties in having the termination of the contract without a cause. Okay, so we need a fair cause to terminate this contract. So any cause, any termination without justification can be a deal breaker, and we need an agreement. But when friends are fighting, an agreement is difficult to reach. Then we have tax implications that having different jurisdictions, it can have variations that are significant. Then also the cross-border issues that international founders create added complexity. So what must be in your European founder agreement, for example? Don't talk only about what is our split. So I have 30%, you have 20, the other one has 10. No. Also, you need to consider the tax implications for each founder residence. Document contribution types. We need to register all the contributions for each one of the founders. What are you giving? For example, if we have A, B, C, and D, so the founder A gave 25K, the founder B gave IP, the founder C gave his home to be the office of the company. So all of these needs to be valued and converted into equity. We need fair equity splits. This is important. And then the other thing that is also important is to plan for different tax regimes, because founder A is in Portugal, founder B is in United States, founder C is in the UK. So all of them may face different rates of taxes. So we need to prepare for this as well. And this needs to be discussed because, when we are discussing, we are being fair to each one of the founders. But what happens is that founder A is paying more taxes and is feeling that is not fair for him. So this needs to be discussed upfront, okay? Because the discussions come after, when we have to pay for the first time taxes. Governance and decision making. So we need to define since the beginning what is the CEO authority, what can the CEO decide since the beginning, what are the limitations of the CEO, what create authority matrix, what needs to be escalated to the board, for example. What the other thing, now that we are talking about the board composition, how you will change the board composition as you scale, for example. Advisors, will the board have advisors or not? Type of advisors, voting thresholds, and then one thing that is very important that we never think that is relevant: if we have a dispute, how are we going to solve it internally before going outside to spend some money? This is very important as well. And IP, I have started to talk about this, but one thing, every single piece of IP must be assigned to the company. Pre-existing IP, because we know that we started to discuss the idea before we decide to incorporate, must be clearly identified and assigned to the company as well. We need to create the invention rules for compliance, all the cross-border IP considerations. For example, the IP is created in Netherlands, but what happens after this? Are we going to apply to ILPO or WIPO? Do we want European protection? Do we want worldwide protection? And this needs to be defined in the business strategy as well, because we need to decide in terms of risk, in terms of money allocation, budget, and legal strategy. For example, roles and commitments. We know that in the beginning, not every founder works full-time for the company. So we have full-time, part-time expectations. What are the geographic requirements, non-compete considerations that also are different by country. Not all the non-compete are enforceable in every country, so we need to check this as well. And of course, salary expectations and timeline. And of course, we don't want anyone to go away and depart from the company, but we have different exit and departure scenarios. For example, if someone is a good leaver, it's a bad leaver, or if it's a performance-based termination. Yes, because founders can also have KPIs. And this is something that we never address because we think that we are founders. We don't have KPIs to fulfill, to achieve. And then geographic relocation policies as well, because in nowadays we think that we are remote and we don't have location. We need policies for this because this can have tax implications for the company and also tax implications for the person that is relocating. So we need to address this. Maybe not immediately in the beginning, but if we want to restrict everything to a location, we need to have the idea of all the implications that this has. Acquisition and exit procedures as well. If you leave the drag along and the tag along clauses as well in the contract, that is, if you leave, all the members of the company can buy it or can oblige you to sell. It depends on what we decide in the company. So I present you some European scenarios. We have German and technical co-founder and a British business co-founder, for example. These can bring different implications, as I told you. We also have, and this is today's reality, remote first team across multiple EU countries. How do we deal with this? UK company based in EU, founders that are post-Brexit, and legal tax complexity factors. Okay, tax residence versus company domicile, employment law in multiple jurisdictions, IP assignment cross borders, and also one thing that is very important is the visa and work permit implications. So what I advise is sit and discuss. Okay, start with the tax reality. We need to understand everyone's tax situation. Okay, where will we be based? The company. Okay, and where, or us as well, where are we tax resident? Use also scenarios, for example, for granting. And if we get this grant, would we move the company, or do we need to relocate the company? Plans for scale. When we are ready for Series A's, what will investors expect as well? This is important because Sometimes we don't raise enough money as well because we don't feel what the investors are expecting from us as well from the legal perspective. So European grant and funding applications, I think I also said this. For example, Horizon Europe requirements, EIC accelerator, national grants, stated rules. From the competition law perspective, it might impact equity structures as well. So what I give you as an action, if you have international co-founders, factor in tax and visa complexities from the start. This is important. So, and this is, if the other one was your policy, this is your protection system, the vesting schedules. So what happens if my co-founder moves back to their home after 6 months but keeps 40% of our company? We want to have something in our contracts that gives you at least the opportunity that if he moves back, we can buy his shares, or we have the right to take a decision on this, because this can have implications for the company that can kill companies, that can kill the company. So and then what is the problem if we don't have it in our founders agreements? Litigation, right? As I said before. And in most of the European jurisdictions, if you don't have a vesting schedule in your founder agreement, what happens is that he is the owner of 40% of the company, unless you have vesting. Okay? So I'm sure that you are all aware of what is vesting, but vesting is the system that you have to earn equity over time. And this also has consideration for European employment and tax law. So, as I said before, we have stronger employment laws in Europe, complex international tax treaties, and different legal concepts of equity ownership. So, the European standard is this one: 4 years vesting with 1 year cliff. How it works? Nothing vests in year one. In the end of year one, we have 25%, and then we have the remaining 75% that vests over the years at a value of 2.8 per month. So why this complies with European law? Employment law is recognized by European investors, UK and EU VCs, provides protection against what we can call founder terrorism. They come, found a company, and they leave in the other day, and they don't work. So I have here different tax considerations. For example, EMI schemes for tax efficient in the employees, share options. Then we have different situations for Netherlands, for Germany. And so we have success stories, for example, with Spotify, BlaBlaCar, for example. So what are the acceleration provisions in Europe? Okay, so we have one that was the most usual before, that was the single trigger acceleration, right? All unvested shares vest immediately upon the company sale. And then we have the double trigger acceleration that are more complex, that is when the company is bought or change of control, we need to verify the local employment law. Okay, so then we have cross-border vesting complications. So if you have equity, a UK company and a German founder, you have Brexit implications for equity holding. If you have a company that is located in Netherlands and you have the equity distributed for a European team, you have multiple tax jurisdictions. The same with Estonian if you have a residency founder. So planning requirements: consider tax treaties between countries before going ahead, understand employment law in founder locations, and plan for potential regulatory changes. So what happens exactly here? For example, the consul, uh, sorry, the consul, the bargaining agreements, all the unions can have influence here. So we need to study really and to have local views of what is exactly that is happening in that country. So we cannot ignore cross-border tax implications, law, and of course, one thing that I see a lot is using US style documentation without adaptation to Europe, because we have a template that a friend gave to us and we are using, or we found in internet, we are using this template. It's very dangerous, and not coordinating with local tax advisors. So if I can give you another action item for the ones that are in this moment preparing for this: if you have invested equity across European borders, get tax advice in each relevant jurisdiction immediately. So European pools, option pools, and how to manage startups. So if we think about the dilemma, how do we compete? Because everyone thinks about this. We don't have enough money to pay to our founders. We don't have enough money to pay to the employees. So how do we compete with Google, with Meta, with all the other European tech giants that pay 150K in salaries? Of course, we have been using it, and we all know that is with equity. But in as I said before, in Europe, equity compensation is more complex than the US model. So what is an option pool in Europe? We have pre-allocated equity that is reserved for employees, with consideration for local tax and employment law. Typically, we have an allocation between 15 and 25% of the company. So UK models, we have enterprise management incentives, like it's the EMI, that has a tax advantage up to £250. Then we have the company share option plan that is less flexible, and we have the share incentive plan as well. For Netherlands, we have share options, certificate schemes, and carried interest structures as well. Germany, we have virtual share plans. France, what I mean with this, we need to know exactly what type of pool are we creating and what are our equity models. I wanted to represent here some diversity the equity on the equity and the employee pools. So what are the essential documents? Share option agreement, employment contract integration, tax election and fillings that is different in every country. Council notifications, we need to notify the council, and regulatory fillings where this is required with the tax authorities. So, and in terms of advisor equity guidelines, typically European allocations for early advisors go from 0.1 to 0.5, strategic advisors with networks from 0.25 to 1%, operational advisors and mentors from 0.5 to 2, and board advisors from 0.5 to 1%. Vesting for advisors usually is 2 years, monthly and quarterly. So, as I said, we have the cross-border team considerations that are different from each country. So this is important. European investor expectations. What Europeans VC look for? They look for a proper legal structure, a tax that has tax efficient schemes, okay, a scalable documentation, compliance with local employment law, and a common pool sizing at the seed stage between 15 to 20%, Series A additional 10 to 15 top up, Series B plus maintain the 15 to 20 available pool. Special European considerations: GDPR and employee data, consent for equity participation and tracking, data processing agreements with service providers, the right to be forgotten. You need to have this in place as well. European Works Council for Germany, Netherlands, France. So action item as well. Before offering equity to your first European employee, understand the tax and legal implications in their country of residence. So, as I promised to give you a 90-day European action plan. So, of course, as everything, this can be adaptable. Week 1, foundation and jurisdiction. Incorporation, jurisdiction, consider target markets, tax administration, incorporate the company, obtain company number, open business bank account. Week 2 to 3, documentation and agreements, founder agreement, tax elections, and set up a cap table management. Okay, European compliant platform. Week 4 to 6, IP and compliance, IP assignment agreement, trademark applications if we need, GDPR compliance basics, and employment law compliance. Week 7 to 12, scale preparation, employee equity scheme design, advisory agreement templates, investment ready documentation, and multi-jurisdiction legal counsel relationships. It's very important for you to have this kind of relationship as well. So we have something that I want you to keep in your mind after I talked a lot, and you might be bored at the moment already, but don't ignore cross-border tax implications. Don't use US templates without adaptation. Don't assume one size fits all across Europe. Don't forget GDPR from the day one, and don't neglect employment law compliance. These are my main advice for you that are from in the other side and listening to me. If you don't remember anything else that from what I said in this moment, these are the key takeaways that I want you to have from this webinar. And also including the Brexit specific checklist. Consider dual UK and EU structure if needed. Understand data transfer implications. Plan for talent mobility restrictions. Review supplier customer contract implications on this. So the most successful European founders I work with treat legal setup as seriously as product development. They understand that in Europe's complex regulatory environment, the right legal foundation it isn't just protection. It's a competitive advantage. Thank you. Any questions?
Actually, just one was, yeah, so I think Ivan has raised his hand. So Ivan, want to say something?
Yeah, so I have a question about the having a Dutch BV and a UK limited, because that's very relevant to me. We've had multiple situations where where we needed a limited to do some sort of subsidy request or something for a customer, and some customers also prefer to deal with a limited. So thank you very much for giving an overview of all the options here, but I must say that I'm still, it's been 12 years since I founded my company, and I'm still looking at the legal part as something that I need to get done quickly and then forget about. So can you go a little bit into the tax implications of having a limited and a Dutch BV? Because to me it's really dazzling, and it looks like I would have to, if I have the limited just written into the Dutch KVK, is that enough, or do I need to really establish a business in the UK and also pay taxes there? That difference is sort of vexing me.
Okay. So this requires more legal tax advice, okay? I will try to help you, okay? But this requires a deeper study of your documents as well, because people, this is something that I want to leave here very clear, is that legal advice without documentation and proper study is something that is difficult, okay?
I understand.
Just to be clear. And I wouldn't trust someone that immediately says, oh, the law says this. No, the law isn't black and white. It's gray most of the times. So your holding company is in Netherlands. Okay. I would say that you have to, I don't know if you have exactly. So the first thing that you need to check is, do I have a double taxation treaty between UK and Netherlands? So you need to know if you have this. If you have, you need to check if you have a clause that exempts the Dutch company not to pay tax, okay? And you need to be prepared with contracts even for money transfer between the two companies. You need to have the two companies situation really regulated by a contract. It cannot stay without a contract, okay? This is what I can tell you without seeing any document. Okay? And if you ask me, I think you have to pay in both and then ask for a refund in Netherlands, but without checking any regulation, any treaty, any law, anything.
Yeah, I understand. So I was afraid of that. It's more complicated than it seems at first.
Yeah,
And that scares me. So yeah, I think I just need some legal advice on that one before I start filling out the forms. And
exactly.
yeah,
That's
thank
why
you.
I say, that's why I have been giving you an action list. So you start thinking. And my action list is to make you think, is not to scare you at all, is to make you think and be prepared. Because preparation is everything in these fields.
Yeah, thank you for that.
Yeah, I think Prabhat also has some question.
Hey, thanks, Marilia, for this great session. So one thing, though, I am from India, so I
Okay?
think like set up the company and organization is really few different than European, but I got to know how to set up in a European country. But really, I love the last part of this session is just specifically you have given the few of the action item. I really would like to get in my mail if you guys can share me, and that would be really great.
That's fine. It's fine.
Thanks.
You can send it to, I think Shikrant can make it
Yeah,
available.
Yep.
Okay.
yeah.
So thank you.
Yeah, I think, I mean, from what I've seen is that even though many people go and start a new startup, but then in many cases, I've seen that when things don't really work, then there are conflicts because of not clearly defined legal framework. And many things you all already shared the different complexities about it as well. So that was, I think, pretty useful and pretty helpful. And I think people uh, who basically participated and will be is it's useful for them. And then I'll share the recording for the people who could not join as well. So thank you so much for your time, actually, Marilia.
Thanks, Marilia.
Thank you.
Thank you so
Thank
much.
you.
Thank you. Bye bye.
Bye, bye,
Bye-bye.
bye.
Thank you. Bye-bye.